Hello and welcome to the second Doyle Clayton podcast. My name is Piers Lee Pollitt. I'm one of the partners at Doyle Clayton Solicitors. We're a firm of specialist workplace lawyers, and I'd like to introduce you to my colleague and fellow partner, Dan Begbie-Clench.
Hello.
And together we will be talking about employment law problems in the context of social media. We'll be looking at a range of issues, including that old chestnut of bringing the company into disrepute, bullying, harassment and discrimination, gathering evidence of an employee's activities while they're absent from work, and also how to deal with expressions of religious belief which appear to conflict with equal opportunities legislation. So quite a packed agenda which we aim to get through in around 15 minutes or so.
Piers, how about I kick off with this one? If I put something on Facebook, surely that's my private profile page and nothing to do with my employer.
That's what you might think, but unfortunately, Dan, it's not that simple. The fact is that even though you might not say who your employer is on Facebook, on your profile or on any of your posts, it's often fairly easy to work out who your employer is from what you write, and of course, many people have their colleagues as Facebook friends. In the case of Crisp and Apple, Mr. Crisp made a number of disparaging remarks about his iPhone and Apple apps on his Facebook page. And when you work for Apple, that's something of a career-limiting move to say the least. He made fun of an Apple marketing campaign that was running at the time. They were using a tagline based on some Beatles lyrics which went, "Tomorrow's another day that you'll never forget." But his version was, "Tomorrow's just another day that hopefully I'll forget." Some of his other comments were rather more disparaging than that. Now, Apple had clear policies against making any comments about Apple products, services or initiatives on social media. They also ran a 10-day induction training where they stressed that activities outside work that could affect Apple's business interests were still covered by company policies and guidelines. So it should have been pretty obvious to all employees that Apple placed a lot of importance on protecting their brand and their image.
So what happened to Mr. Crisp when Apple found out about his Facebook postings?
Well, as soon as he was alerted to the unacceptable nature of the posts, he removed them. He said his Facebook page was private, and he pointed out it didn't say that he worked for Apple. He even tried to argue that his negative comments about work were in fact references to his work as a reservist in the TA. Understandably, that didn't wash with his employer, and he was dismissed for gross misconduct for bringing the company into disrepute.
And so he brought an unfair dismissal claim after he was sacked?
Yes, the tribunal held that the dismissal was harsh, but it wasn't outside the range of reasonable responses. So in other words, it was a fair dismissal.
And why did the Employment Tribunal think it was harsh to dismiss him?
Well, because he'd removed his comments as soon as he was made aware that they weren't acceptable. He'd not said he was an Apple employee on his Facebook page, and also his security settings made the comments available only to his Facebook friends, not to the general public.
And why did the tribunal think it was a fair dismissal overall?
Because of the clear policies and procedures in place, and the fact he contravened them. The tribunal said that even though it didn't find he was posting comments in the public domain, it also said there was no reasonable expectation of privacy either, because there's a potentially far wider circulation than his intended audience, given the capacity to share comments outside his circle of friends.
What about the argument that clamping down on what people say on their private Facebook page is a breach of their human rights? So, for example, the right to freedom of expression or the right to respect for private and family life?
Well, that was tried in the case of Taggart and Teletech. This was a case involving a chap called Mr. Taggart who'd been employed for 4 years as a customer services representative. He'd posted an abusive message on Facebook when he was at home, outside of work hours, about one of his colleagues. The colleague was told about the post by one of her colleagues and asked Mr. Taggart's girlfriend, who also worked for Teletech, to remove the post. He refused, and to make matters worse, he added insult to injury with a further abusive remark about her. He was then dismissed for making inappropriate comments on Facebook about a colleague, which were held to have amounted to bullying and harassment, and he was also sacked for bringing the company into disrepute.
And did the Employment Tribunal agree that it was gross misconduct?
Well, they didn't think that Mr. Taggart had brought Teletech into disrepute, but they did think he'd harassed one of his colleagues. It was irrelevant that he hadn't, in fact, made the comments directly to the colleague in question, or that she'd found out from a third party. So it was held that his dismissal for gross misconduct was a fair dismissal. Now, as I said, he also tried to argue that he had the right to freedom of expression and also a right to respect for family and private life, and that these should have been taken into account by the tribunal.
And did the tribunal give any weight to these arguments?
Not in the way he would have hoped. The tribunal felt that the exercise of those rights and freedoms is still subject to other restrictions that are prescribed by law, including the need to protect the reputation or the rights of others. So those arguments were given very short shrift. Dan, one for you to answer this time. What happens if someone claims to be sick and yet their Facebook entry shows them having a load of fun at a party?
Well, that could be grounds for gross misconduct if the employee has misled the employer about their absence. It all depends on the context, as you can see from the case of Gill and SAS Ground Services, which was about an employee who'd been signed off work for 3 months for surgery. Now, near the end of her sick leave, she posted up on Facebook that she was attending London Fashion Week, and it turned out she was also doing some work there as a part-time model. One of her colleagues was friends with her on Facebook, saw the posting and was very put out that she seemed to be off having fun at a fashion event when she was supposed to be off sick and unable to work. The colleague brought it to the employer's attention and the employee was then sacked for gross misconduct.
Surely she can attend events even if she might still be too unwell to work.
Well, it's true that attending an event might not be at odds with an employee being signed off work with ill health, but in this case, she'd given the employer inconsistent information about her recovery, and she also appeared to be working at the event. So the Employment Tribunal also took into account that her colleagues might be demoralised to see her attending events while she was receiving full company sick pay. So to go back to your question, just because an employee seemed to be doing things on Facebook when they're signed off doesn't necessarily mean that they've committed misconduct. It really depends on the absence and the reasons for it.
And did the employer have any business looking at her Facebook page, though? Couldn't she rely on it being a private posting?
It wasn't an issue in this case, as the employer hadn't been snooping on Facebook. The employee had friended her work colleagues on Facebook, and it was one of those colleagues who saw the posting and complained about it to the employer, so she couldn't expect to have any right to privacy in this case. Piers, we've talked about employees putting up silly things on Facebook. Now, let's turn to Twitter. Can people say what they like on their own private Twitter feed?
Well, as is always the case, Dan, it depends on the facts and how private is private. This is precisely what Mr. Laws tried to argue in the first EAT decision on Twitter misuse, Game Retail Limited against Laws in 2014. Mr. Laws was employed as a risk and loss prevention investigator for Game Retail and had over 16 years' service. One of Game Retail's store managers notified the company about tweets that had been posted by Mr. Laws on his personal Twitter feed. They found that 28 posts were offensive, mainly because they used foul language. For example, on one occasion he said, "This week I have been mainly driving to towns in the arse end of nowhere. Shut roads and twats in caravans equal road rage and lots of fags smoked." Mr. Laws didn't specifically mention his employer on his account, but it's important to note in this case that Game Retail stores use Twitter and other social media for marketing purposes. Also, each store had its own Twitter feed, which was followed by a large number of customers. Mr. Laws also followed the stores that he was responsible for on Twitter, and in turn, he was followed by up to 65 stores for which he was responsible. When he was challenged, he also took down his Twitter feed.
So he was a long-serving employee, and when he was told about it, he deleted the tweets and his Twitter account. Did that help him in the disciplinary process?
Not much. He was still dismissed for gross misconduct.
So he brought his unfair dismissal claim. Whose side was the Employment Tribunal on?
The tribunal held that the decision to dismiss was outside the band of reasonable responses and was therefore unfair. The tribunal did, however, make a 40% deduction to his compensation award on the basis of his contributory fault.
So the employer lost the Employment Tribunal case. What happened afterwards?
Well, the employer, Game Retail, appealed to the EAT, which remitted the case to a fresh tribunal to decide whether the range of reasonable responses test had been properly applied. But the EAT made it pretty clear that some of the employment judge's findings were questionable. There were 3 issues. The first issue was whether the comments on Twitter were genuinely private. The tribunal said that they weren't made in work time and were for private use only. However, the Twitter feed was very widely read and had no restriction settings put in place. The second issue was whether the comments were in fact offensive. The tribunal said that there wasn't any evidence that any employee or customer was actually offended by his tweets. The EAT said, however, that can't have been right because one of the store managers notified the company because he had been offended by the tweets, so at least one person was offended. The third issue related to the content. The judge had considered it relevant that Mr. Laws had not posted anything derogatory about game retail or anything that might reveal that he worked for game retail. The AT thought this could be a perverse finding. Mr. Laws was following about 100 stores and was followed by 65, so it was pretty clear to quite a few people that he was working for game retail.
Piers, we haven't seen any cases where the appeal courts have given general guidance on social media cases. Wasn't this a situation where the EAT was invited to provide some guidance?
Well, yes, they were, but they refused. They said any guidance that they could give would be so general as to be unhelpful. Now, we would have benefited from some guidance, but their view was that questions are so fact-sensitive in each case that it wouldn't have been of any use. So there we go.
So we could easily find in social media cases that with different facts we get a different result.
Yes, and that's always the way. If there had been a genuinely private Twitter feed, if the posts had been less obnoxious, we could have ended up with very different results. So final question for you then, Dan. What about expressions of religious belief which appear to conflict with equality legislation? For example, if a Christian man doesn't support gay marriage, how far can he go in expressing that belief?
It's a bit tricky because employees are entitled to hold their own beliefs about religious issues. But the rub is where the employee might publicise those views in a way which offends colleagues or which conflicts with company policy. The High Court looked at this in the case of Smith and Trafford Housing Trust, and it was a case which turned on a very fine distinction between whether the employee had promoted his personal religious views or whether he was simply expressing them. And it's also an interesting decision because the employer had a contractual code of conduct which required the employee to behave in a non-confrontational and non-judgmental manner and also not to bring the employer into disrepute. And this was stated to include not promoting personal religious views.
Which presumably is exactly what he did.
Yes, well, he was friends with a large number of work colleagues on Facebook, around 45 of them, and his Facebook profile page stated that he was employed by the Housing Trust. Mr. Smith posted up a link to a news article on the BBC website and stated that he was against gay marriage taking place in church. He said he thought it was an equality too far. This was at the weekends, outside of working hours. Now, some of his colleagues saw this posting and were offended by his views and complained to the employer, which then started disciplinary proceedings against Mr. Smith as, in the employer's view, he'd breached the code of conduct.
Again, surely this is something that he did in a private context, if it was his personal Facebook page?
Well, the employer decided that it could be gross misconduct because, in their view, he was promoting his personal religious views, that he didn't agree with gay marriage taking place in church. And this was when the contractual code of conduct required him not to do that. And as you say, there was a question about whether he'd done this in a private context. But in the employer's eyes, effectively his Facebook page was seen as an extension of the workplace, as it made clear that he worked for the Housing Trust and he was connected to so many work colleagues on Facebook.
So they sacked him for gross misconduct, did they?
Well, no, he was a long-serving employee, so although they found that it could be gross misconduct, rather than sacking him, they decided to demote him instead and also reduced his pay. He then sued in the High Courts, arguing he'd not breached the code of conduct and that he'd been demoted in breach of contract. And this is where this case appears to differ from the others that we've looked at, because the High Court decided in the employee's favour. The court thought that his anti-gay marriage comments were not in breach of the employer's code of conduct because, in this case, they felt he wasn't promoting his personal religious views, rather he was just expressing his beliefs in response to a comment made by another colleague on the Facebook page.
So, Dan, do you think that conflicts with some of the other cases we've looked at?
Exactly, you can see some confusion. There are cases where the Employment Tribunal has found that what an employee does on Facebook can have a direct impact on their employment. Yet in this case, the High Court decided that the employee was entitled to express his religious views on Facebook, even though those views seem to be contrary to the employer's rules, and even though his Facebook page did directly link him to the workplace. The court decided that this was a case which illustrated the price of freedom of speech, and as I said before, it really turned on this fine line between whether the employee was promoting his personal religious views or simply expressing them. So that summarises some of the most interesting cases on this issue. And I'm sure those of you who employ people are thinking, what can I do to deal with the issues? You might come across scenarios where your employees have posted something on Twitter or Facebook which is in breach of your company policies, or even which amounts to bullying of work colleagues. Well, the best starting point is to have a clear policy in place dealing with social media, both from the perspective of how it can be used to benefit the company, and also in terms of the limits which you expect employees to comply with when they use social media in a personal capacity. One of the themes that we see from these cases is that the courts are reluctant to find that employees have brought the company into disrepute by simply posting something up on Facebook.
Yes, I think that's right, Dan. I mean, the courts seem to be saying no right-minded person would believe that the extreme views of some of these employees would also be the views shared by their employer. So, in your policies, you need to spell out exactly why employees need to be careful when posting things which could have an impact on the workplace. For example, you can explain that they might do something on social media which could amount to offensive behaviour, including bullying and harassment. They need to understand that even a social media posting which is made from home, outside of working hours, can still be potentially treated as part of their employment. The policy should also make clear that social media is no different from any other disciplinary issue. So things like breaches of confidential information, bullying and harassment of colleagues on social media can still be treated as disciplinary matters.
And it should go without saying that having a clear published policy in place will help you to address social media issues more easily and consistently, with less risk of a successful unfair dismissal claim from employees. And one final point. The other benefit is that your social media policy could also include details about your ownership of LinkedIn profiles and business contacts which your employees make on LinkedIn, because this is another tricky issue for employers, especially when dealing with departing employees.
So thanks, Dan. That brings us to the end of the podcast. Of course, if you have any questions at all, then please contact either Dan or me, or your usual contact at Doyle Clayton. Feel free to give us a call on our City Office line, which is 0207 329 9090. Many thanks for listening.